We're here today on the State of Ohio versus Roger Ward, two different cases. The criminal action is CRB 23-00012, and the traffic citation case is TRD 23-00059, charges A, B, and C. So, just so we have it for the record, the criminal case involves obstructing official business, a second-degree misdemeanor, and the traffic citation case involves a no operator's license charge, which is an unclassified misdemeanor, non-jailable offense, a registration violation, and a license plate requirement. Those are minor misdemeanor, unjailable offenses, or non-jailable offenses. And we were originally set for a jury trial today, and we had continued the trial either once or twice before. I can't remember, but I was definitely involved in the last continuance, and we rescheduled it for today, jury trial. Subsequent to that, Mr. Ward filed defendant's demand for dismissal with prejudice, and a request for a hearing with that. Court is going to construe that as a motion to dismiss, which is the same thing, just semantics. And so once that came forth, we converted the jury trial date of today to the status conference. No, we didn't. A motion hearing on that motion to dismiss. So there have been numerous other motions filed with the court while these cases have been going on, and I believe every other motion has been resolved or dealt with by entry thus far, except for this demand for dismissal. So, having said that, on behalf of the state of Ohio, I'll note that you're here today. We've been waiting for the appointment of the special prosecutor. Your office requested that a special prosecutor be appointed back on March 3rd, and they sent me the motion and entry, and I signed the entry on March 3rd. I think that's what the timestamp bears. So, and the reason for continuing the last jury trial date was because there had not been a special prosecutor appointed. So here we are again without our special prosecutor, or a special prosecutor. It was just my understanding your office had effectively recused on the case.
That's correct, Your Honor.
Okay, and for whatever reason, I don't need to know why, but and it's not relevant to what we're doing here anyway. So, Mr. Ward, you've been representing yourself throughout these proceedings, and so let's deal with this motion, or demand for dismissal, or a motion to dismiss. And on behalf of the prosecutor's office, are you planning on participating in this motion hearing?
Your Honor, I've been speaking with the prosecutor, Randy Dupree, and he wanted me to follow up and give a synopsis of what happened since then. They're trying to locate the prosecutor on the case at this point.
Okay, well, why don't you let us know that now?
Absolutely. Your Honor, after speaking with Prosecutor Dupree, he did inform me that he has reached out to numerous prosecutors, I don't want to say, also he's reached out to hired attorneys as well too. Nobody had the opportunity to take this case or been able to take this case. He did speak with, I believe, a prosecutor over in, I believe, either Piscataway or Benton County, and they did state that they may be able to take the case on, that they did have a jury trial that was coming up, and that's the reason why they were not able to find the case yet.
All right. Okay. Thank you. Mr. Ward, anything you'd like to say?
Yeah, I thought it was coming for a good trial, but so I didn't have really time to prepare for the hearing, but I did jot down that I'd like to read my oral argument.
Okay.
I stand before you today as defendant Roger Ward. I am here in response to a gross failure to due diligence by the state of Ohio, necessitating a dismissal with prejudice of the above cases. The foundation bedrock of American justice system is due process, which stipulates that an individual's legal rights must not be curtailed or restricted without proper administrative procedures. Our system's strength and credibility rest on each party upholding their duties and responsibilities. Regrettably, in this case, the state of Ohio has grossly neglected its duties. I have made numerous efforts to advance this case, including filing several motions, pursuing discovery, sending repeated correspondence, and even filing a motion to compel the prosecutor to compel the discovery. Despite these painstaking efforts, there has been a stunning silence from the prosecutor's office, which in itself is a direct violation of due process. Furthermore, it is my contingence that Magistrate Judge Jill Shriver overstepped her jurisdiction in the absence of any formal consent from all parties involved. The resulting shift in the trial schedule not only infringed upon my rights, but also provided the prosecutor with an unfair advantage. The infringement is compounded by the failure of the prosecutor's office to appear at the scheduled jury trial on 421, further delaying the proceedings and frustrating the administration of justice. But perhaps most egregious is the incident involving the backdating of the continuance entry by the clerk's office, effectively undermining the legal legitimacy of the court's proceedings. This incident, corroborated by emails, records, and docket entry, marked as an exhibit with my motion. I stand before you with a simple, straightforward demand. As per Rule 41B1, I demand that these cases be dismissed with prejudice on the grounds of failure to prosecute. The demand is not merely about technicality, it is fundamentally about preserving the sanctity of due process and the integrity rights of the defendant. The defense is not asking for any special treatment. I merely seek the basic rights promised to every American under the law, in fair and timely trial. It is evident from the course of the events that the prosecutor's office has not upheld its duties, and it has severely hampered my ability to receive a fair trial. In conclusion, I request that this court uphold the principles of justice, dismiss these cases with prejudice, and ensure that the civil rights of Roger Ward are not further violated. I trust in this court's ability to discern and deliver justice as it always has for the benefit of all parties involved. And also, I would like to point out that when the continuance was entered on the 21st, backdated for the 19th, the continuance is only for the criminal case and not the traffic case. So I showed up, nobody showed up on there for the trial, so it was never continued, but nobody showed up. And that's all, Your Honor. Thank you.
Okay. Yeah, I did note, in fact, right after I got here, I noticed that when I rescheduled the case for status, I think you may be talking about something else.
Well, this was set for jury trial on the 21st, and I showed up, and then the only one that was continued was the criminal.
I believe I sent two different entries in.
This is the only entry I got. That's the only entry on record.
And you may not have received the cancellation of the jury trial for today.
Oh, they handed it to me when I walked in.
Yeah, I did it last Friday.
Right, but I'm talking about the prior one.
The prior one, yeah.
Yeah, there was no continuance on the traffic cases at all.
Okay.
And they were scheduled for April 21st, Your Honor.
Okay. Let me see if I did that. Well, somewhere in here I have the continuances, but in any event, we're here today for the motion hearing, and on behalf of the state, did you want to present anything with regard to the motion? Oh, okay. Yeah, I'm a little bit frustrated here that we don't have a special prosecutor. I haven't had this happen before. I've been doing the visiting judge stuff for about a year, or a little bit over a year actually. And even when I was on the bench in Franklin County, we never had problems getting a special prosecutor.
Right.
But, so I don't know what the holdup is, but you have rights, and I'm going to recognize those rights, that these cases have been delayed unreasonably. And we are actually running out of speedy trial time. I did a rough calculation of speedy trial, and my calculation is it would be somewhere around July 4. So we're definitely running out of time. But when I did that, I was surprised that we weren't already out of speedy trial time. But you get 90 days on the most serious charges. So in any event,
That would be over then, wouldn't it? It happened on January 2nd.
There's different ways to count the time.
Okay.
So that it's told when certain things happen, like you demand discovery. But in any event, I just did a rough calculation on it to get where that date was. But at this point, with regard to both cases, I'm going to sustain the motion to dismiss, and I'm going to dismiss each of the cases. I'm a little bit uncomfortable dismissing them with prejudice. And you're citing Rule 41. That is a civil rule. So you've got, and I know you're not an attorney.
That's what the whole point when it first appeared. That's what I was trying to understand the jurisdiction, whether it was civil rules or the, in traffic it has to do with civil in the first hearing. So I didn't, I just.
Yeah. I know you're not an attorney. I'm not trying to hold you to that standard either. But I was trying to point out in some of the entries I had previously done, the difference between the civil rules and the criminal. So you have rules of criminal procedure, and then you have rules of civil procedure, and they don't overlap.
Right.
You also have traffic.
I got a question. What would the traffic be? Would that be considered under the rules of civil or rules under the rules of criminal?
There's also traffic rules, but it more or less, if you want to think of it simply, it more or less is under the criminal.
Okay.
So, and I know the confusion there if you aren't schooled in it. So, not a problem. I'm not holding any of that against you. But Rule 41, once again, a civil rule, does allow a dismissal with prejudice for certain things. But I'm going to dismiss both of these cases without prejudice, which means they can file them again. I'm not sure if they will. That's not my call. But if they do, I'll probably get the nod again.
Okay. Can I also get you to enter something to demand getting my truck back and my trailer?
Do you not have those?
No, they took them, and I went and paid the impound on the 6th, the day out of our court, and they wouldn't give it to me.
I have no idea why they're holding them.
That's why I went to. That's all I wanted in the beginning of the whole thing.
Yeah, I would. You know what? I would imagine with these cases going away, they would have no reason to hold them.
They didn't have no reason to hold them before. I paid the impound, and they wouldn't give it to me. Because it wasn't registered or something, I don't know.
Well, did they say anything about the registration? When I read this, I saw that the license had expired for the pickup, and there wasn't any license at all on the trailer.
Right.
I'll tell you what. I'm going to do written entries, one for each of these cases, and within that entry, I'll order that the truck and trailer be returned to you.
I appreciate that.
So I don't know if they're going to make you take it out on a rollback or what.
But either way,
there's no license.
Fine.
Or you can just, if you re-up the tags, then that would take care of that.
It's just a farm truck, so I don't want to deal with it.
Okay. So, in any event, anything else on behalf of the prosecutor's office?
No, no.
Okay, Mr. Ward, anything else for today?
No, I think so.
Okay, so the cases are dismissed. I'm going to, well, I'm not sure if I can get home in time now to do the entry today, but if not, it'll be, I'll try to get it done over the weekend because I've assigned somewhere else all of next week. So, but I'll get it done here within the next several days. Okay. All right, yes, I've got that on the citation here, and you'll get the entry in the mail then.
All right, I appreciate it.
Okay.
Thank you, Your Honor.
Court will stand in recess.